All right, this case at D-436-896, the Gellner case. Counsel for the record.
Emily McFarling, bar number 8567, here on behalf of the plaintiff, Sandra Gellner.
And Robert Luke, bar 1489, on behalf of Mr. Gellner. This is stuck in here.
Stuck on the bottom. Yeah.
There you go.
Wow. All right, this is on plaintiff's motion. There's an opposition and counter motion. Let me start with what I call the kitchen sink sort of stuff. So, did you look at the history of the minutes in the case? The reason I asked that is because it's already come up. And through her prior counsel, I'll cite you the minutes from September 12th of 2012 regarding the Civic, the Accord, and all that other fun stuff that was argued back and forth. Quote, Mr. Roy advised that the issue of the sale of the 1998 Honda Accord is no longer an issue. Court, and there was repairs of the vehicle, etc. So that was done back in September. On the record.
Review that.
So that was done. I have to say, the issue of, I believe it was a grandfather clock and something else, right? First, that's popped up in the numerous hearings we've had before. Do you have the item she's indicating you still have?
Yes, Your Honor.
And go, listen.
We traded. I bought her a dining room set and some furniture. We had a verbal agreement. And
I don't do verbal agreements. I can't do verbal agreements. If
I
you
have a
modify
receipt.
the decree of divorce, you have to do in writing in the same way. That's what the statute provides. All I can do is enforce orders. If the order says she gets it, I guess go over and pick it up.
Well, that creates a problem because a lot of people change things after they're divorced, and this was an informal arrangement.
Look,
And
first of all, I don't.
She got it. Then we'll go back and pick up the dining room set then. You know, if you want to play that game, we'll go back and pick up the stuff.
Listen, what the parties, once they make these subsequent agreements, they get the misconception that I get to follow them around the rest of their lives, and especially when they have these great relationships and make these side agreements. I don't. All I do is enforce my orders. If they and you know, the statute indicates the only way to modify the decree is executed in the same way as a decree. Stipulation in writing, acknowledged, executed, all the same. These other side agreements, I don't enforce that. All I can enforce is the decree. He wants to enforce his unwritten agreement. He's not going to do it in my court. He can do whatever he wants. He can go sue her in small claims court for all I care.
Okay.
I don't. So, let's get to, I guess, the biggest and main issue. Mr. Farr, let me give you, I guess, let's start with, everybody thinks that family court's a little different. Let me give you some hypotheticals in other areas of the law. Let's say in a capital case, your client represented herself. In that case, she got convicted of murder and was sentenced to death. She goes, you know what? If I would have had an attorney, I would have submitted just a little more evidence. I don't think I'd be sitting here on death row. Courts don't allow that. Same thing in a civil case. Let's say she had a multi-million-dollar civil case. She had a great case. She represented herself because she didn't want to have to pay attorney's fees. She didn't submit sufficient evidence, and she got a goose egg verdict. And then afterwards, goes, you know what? If I had just done a little bit more, I think I would have got that $1 million verdict. So let me file a new suit. What would they do? There's no difference. It's res judicata. It's unfortunate. Your client seems like a nice person, but it's absolute res judicata. So unless and until she has something different than the facts and circumstances she had at the time, I can't consider it. I absolutely can't consider it. I can't consider the fact that her husband resides in California. I can't consider all those same things that was pled before, because all this is a serial motion. Absolutely is a serial motion. And I'll tell you my frustration, because let me give you a little bit of the history. First of all, the notice of entry on that case was entered on, I showed December 5th. You filed for a motion for reconsideration and a new trial, all that fun stuff. It was set in due course in March 19th. I take it upon myself, which I did. I did a minute order. I reviewed it, because if you had gone in normal course, you would have foregone your rights of appeal. I did a minute order, purposely. So you had still a couple of weeks, your client's thought a couple of weeks. If you weren't happy with what happened, she could have gone and done whatever she wanted up at Carson City. She didn't do it. But at this point, McMonigle, there's language in the Mosley case, there's language in Castle versus Simmons. It's res judicata. It's unfortunate, maybe, but there is no, and I'm still waiting for that one case that some attorney swore that's out there. I have to treat pro se litigants a little bit different and throw all the rules away. I don't. I can't. I have to treat everybody the same. That being said, tell me one fact and circumstances that's changed since the entry of the decree, which would be March, that is any different than she submitted when she wanted to move before.
The big difference between her prior counter motion and this motion is that previously they had joint physical custody. That order at the time she did her counter motion was joint physical custody. As a part of those proceedings, she got confirmed as de facto primary. So her standard to meet for a relocation is significantly different now than it was when she was initially pleading the issue. Number one. Number two, I mean, just passage of time and changes in their situation, the timeshare, all those things are different now than they were a year ago. And on top of it, the prior motion was denied without prejudice. And I understand your analogies to
given.
criminal cases and civil cases and all that. But this isn't the same type of situation as a claim like that. When you have children and you have requests for permission to go do things, children are an always evolving thing, and you certainly do not want to condone serial litigating the same issues.
It is the same issue, though. It's absolutely the same issue, and I disagree. I mean, if you want me to go back and look, I don't think that was a standard incorporated on that day. I show your client has always had, and I'm assuming it was on that day, primary physical custody.
It was not the standard incorporated on the day of the evidentiary hearing, but it was the standard incorporated the day that she filed her counter motion, when she came to the court requesting permission. And so
that's a reach. That's a reach. I understand. It's kind of sad. It really is. But I can't. You're not telling me anything that's changed. I'll submit that I can't take in consideration, because when I looked at your motion, your writings, it's the same motion. It's the same as her original motion. I don't see anything differently.
And under McMonigle, you're not supposed to go in and relitigate or consider facts that were presented. The facts that she wants to bring to the court now were not presented, and I guess that's where the problem comes in.
But she had every opportunity to do it. She had the opportunity.
That was her. Present them.
It was her choice. Again, we're back to, you're trying to treat family law different than any other, and I'll submit it isn't. It's res judicata. She had every opportunity that day. She had every opportunity to even ask for a continuance and get an attorney. Again, the frustration in this case, I remember the case. I told her, these are hard cases. Get an attorney. Do it right. She chose not to do that. We even took several breaks so she could consider testifying herself. She decided not to do any of that. I myself gave her additional time if she didn't like it to go up north and try to get it sent back. I would have done that. I'm not offended by people appealing me. But I can't. It's absolutely res judicata. And unless you can cite me something differently, and I don't, because you don't cite me anything different, that it's family law, so it should be treated a little bit differently. It's absolute McMonigle. It's Mosley, it's Castle, it's all those talking about res judicata.
But when you have a decision in a criminal case or a civil case or whatever, there's a distinction.
Civil. First of all, this is civil.
There's a distinction between a decision made with prejudice and a decision made without. When you get a decision with prejudice, and most of them in those types of cases, civil, criminal, that's a final decision and you can't ever go back. But you have examples of situations in civil cases, regular civil cases, where you get a decision without prejudice, such as a motion to dismiss a complaint for fraud because it wasn't pled with specificity. It gets dismissed without prejudice. You go in, you get the specifics, you refile, and you have the opportunity to come back again. Even though it was something that was already pled once before, when you have that without prejudice dismissal or denial or something, you have the opportunity to go back and bring that same claim again.
And along that same analogy, she has every right if, let's say, for instance, she marries a different guy who lives in South Dakota. Okay, you're right. She does. I cannot deny her from ever leaving the state of Nevada. But the same facts and circumstances as she already had the opportunity to adjudicate, and that is res judicata. And again, I mean, that's going to be my finding. I'm going to deny the motion today based on that. And I guess I'll have 30 days from today to see if the Supreme Court agrees with me on that. But I can't otherwise.
Your Honor, I generally, although I talk a lot, I also know when to shut up.
Okay.
I mean, there is, in addition to what you said, there's also claim preclusion.
It is. It's all the same line of stuff.
Yeah, and all that.
It is.
Very similar things. And there's a recent case that says even with a dismissal without the prejudice of a civil case, this year the Supreme Court upheld the dismissal of a Nevada case that tried to relitigate the same issue. So without prejudice is not always have a
Well,
whole lot of
let me be
operation.
clear. I issued that minute order regarding without prejudice because I can't in custody cases, and like the analogy, I can't say she can't move out of state with prejudice, we're done. I could never do that. She has every right to come back and petition this court to relocate out of the state of Nevada, but not under the exact same facts and circumstances as she's already submitted because it's issue preclusion.
I'll prepare the order, Your Honor.
All right, have a good day.
Oh, wait, one more issue. We have a request for an order to show cause on his non-payment of child support. He is in arrears. When we filed the motion, he was in arrears.
I have a schedule.
$3,700.
Listen, that was brought up before. There was other issues. I don't have a schedule of arrears.
We're not asking for the arrears to be reduced to judgment today. We're asking for an order to show cause for contempt for him for the non-payment of those.
Whenever there is an allegation regarding the local rules, I have to have a schedule of arrears, right? Pull up the OSC stuff. And again, I don't know what time period she's talking about because, again, I thought that was another thing that had already been.
It was also raised in the last proceeding.
I thought there came a point when everything was even, but EDCR 5.33, whenever you file a motion for asking for arrears, it's
Asking for arrears. We're not asking for arrears to be reduced to judgment. We're asking for an order to show cause for contempt.
You know, again, in all due respect, I believe this is sort of a kitchen sink. You want to refile, I'll make that finding without prejudice. I'm going to require you file a schedule of arrears, and I'm also going to require you and Mr. Luke, pursuant to EDCR 5.11, try to work it out first, and then if it gets to that point, it cannot get worked out, assuming, again, it's not already been addressed, because I thought it had been. You can file a schedule of arrears and do the normal protocol. Have a good day.
Thank you.
Thank you.